Building on the previous section's discussion of reasonable skill and care, one of the most essential applications of that duty is knowing what information a licensee must disclose to other parties during a real estate transaction. Disclosure is both a legal obligation and a professional standard rooted in Arizona law. It ensures transparency, protects consumers, and upholds the integrity of the real estate industry. While confidentiality remains a core fiduciary duty to clients, disclosure is equally important when it concerns material facts that could affect a party's decision to buy, sell, or lease a property. The balance between these two duties, confidentiality and disclosure, defines a licensee's ability to act ethically and lawfully in complex transactions. Under Commissioner's Rule R4-28-1101B, a licensee must disclose in writing to all parties any information that materially and adversely affects the consideration to be paid for a property. This rule applies regardless of whether the licensee represents the buyer, seller, landlord, or tenant. A material fact is any piece of information that could influence a party's decision to enter into or complete a transaction. Examples include structural defects, flood hazards, zoning violations, roof damage, pest infestations, or pending legal actions that impact ownership. Even if a client prefers that the agent not disclose such information, the law requires it. A licensee's duty to disclose material facts to all parties overrides the client's desire for secrecy because it serves the public interest and prevents fraud or misrepresentation. This duty was clearly articulated in the landmark case Hill v. Jones, 1986. In that case, the Arizona Court of Appeals held that sellers and their agents must disclose known material facts that could affect the property's value, even if those facts are not readily observable. The case involved termite damage that was not disclosed to the buyer. The court ruled that failure to disclose such damage constituted misrepresentation, emphasizing that a duty to speak arises where material facts are known to one party and not the other, and the failure to disclose would be unfair. This ruling established that silence regarding a material defect is equivalent to deceit under Arizona law. Another example of disclosure can be seen in the Lombardo v. Albu, 1996 decision, which reinforced that a licensee's duty to act with honesty and fairness extends to all parties in a transaction, not just clients. The court affirmed that withholding material facts, even unintentionally, could result in liability for negligence. Thus, disclosure obligations exist regardless of agency relationships. Licensees cannot hide behind client representation to avoid responsibility. Let's apply these principles through a practical scenario. A listing agent learns from the seller that the property's air conditioning system frequently fails, but the seller instructs the agent not to mention it to potential buyers. Because this issue materially affects the property's value and desirability, R4-28-1101B requires the agent to disclose the defect. Even though the seller is the client, the agent must act in compliance with the law and disclose the issue to protect the buyer from harm and themselves from disciplinary action. The Arizona Department of Real Estate, ADRE, has disciplined many licensees for following a client's unlawful instruction to conceal property defects, viewing such conduct as dishonest under ARS Section 32-2153A3. Similarly, if a buyer's agent learns that the buyer plans to resell the property immediately at a higher price, this information typically does not have to be disclosed to the seller unless it directly affects the transaction or involves deceptive intent. However, if the buyer's plan involves illegal conduct, such as using fraudulent financing, the agent must report it to the appropriate authorities or risk complicity. Disclosure is therefore situational and depends on whether the information is material to the fairness and legality of the transaction. The seller's property disclosure statement, SPDS, A standard document used in Arizona real estate transactions is an example of how disclosure obligations are operationalized. The SPDS provides sellers with a structured form to disclose known material defects. While completion of this form is not legally required under statute, it has become a standard industry practice to ensure compliance with disclosure laws. And to minimize disputes, agents are responsible for explaining the importance of accurate and truthful completion of the SPDS to their clients, as failure to disclose could result in post-closing litigation. Disclosure also applies to matters of agency representation and compensation, as discussed in earlier modules. Under R4-28-1101D, a licensee must disclose in writing whom they represent and whether they are receiving compensation from more than one party. For instance, if a broker represents both the buyer and seller under limited representation, this must be fully disclosed and consented to by both parties. Similarly, if a licensee receives a bonus or incentive from a third party, they must disclose it under ARS Section 32-2153A22. Transparency about representation and compensation prevents conflicts of interest and builds trust. In addition to property defects and representation, licensees must also disclose latent environmental hazards that could affect safety, such as mold, asbestos, radon, or lead-based paint. For homes built before 1978, federal law requires lead-based paint disclosure under 42 U.S.C. Section 4852D, and Arizona law supports similar disclosure requirements for environmental and safety issues. However, licensees are not required to investigate or verify such conditions unless they have actual knowledge of them. Reasonable skill and care, as discussed in the previous section, require agents to refer clients to environmental inspectors when potential concerns arise. There are, however, limits to what must be disclosed. Arizona law, under ARS Section 32-2156, specifically exempts licensees from disclosing information regarding deaths, suicides, or HIV/AIDS-related illnesses that occurred on the property, as such information is not considered a material fact. Similarly, agents are not required to disclose the demographics or personal characteristics of current or past occupants, as doing so could violate fair housing laws under both state and federal law. In every situation, the safest course of action is to err on the side of disclosure when in doubt. Failing to disclose material facts risks not only civil liability, but also disciplinary action by the ADRE licensees, who prioritize transparency and documentation, protect themselves, their clients, and the integrity of the profession. Review summary. Disclosure in Arizona. Real estate is governed primarily by R4-28-1101B and reinforced by court decisions such as Hill v. Jones, 1986, and Lombardo v. Albu, 1996. Licensees must disclose all known material facts that could affect the value, condition, or desirability of a property. This duty applies to both clients and non-clients, regardless of agency relationships. Agents must balance their obligation of confidentiality with their duty to protect the public. Certain information, such as deaths, illnesses, or non-material personal details, is exempt under ARS Section 32-2156. Ultimately, disclosure preserves fairness, honesty, and trust in every transaction. Discussion. What is the primary purpose of disclosure under Arizona real estate law? Answer. To ensure transparency, protect consumers from harm, and prevent fraud or misrepresentation in real estate transactions. When must a licensee disclose a material defect to other parties? Answer. As soon as the licensee becomes aware of it, regardless of whether it benefits or harms their client. What type of information is not considered a material fact under ARS 32 2156. Answer: deaths, suicides, or HIV/AIDS related illnesses that occurred on the property. Closing remarks. Disclosure is one of the cornerstones of ethical and lawful real estate practice in Arizona. It reflects honesty, builds credibility, and upholds the public's trust in licensed professionals. By consistently identifying material facts, disclosing them promptly, and maintaining accurate records, licensees honor their duty of reasonable skill and care while avoiding legal and disciplinary risks. In every transaction, integrity and disclosure is the difference between professionalism and liability.